Guten Morgen and good morning, and a warm welcome to this panel discussion. My name is Johannes Grönert. I'm the head of Brussels office at the TÜV Association, and I will be your moderator for this discussion. As we have non-German speaking panelists with us, we will hold this debate in English. Just as last year, we will dive into the upcoming EU regulation for artificial intelligence, the AI Act. And as you know, there have been lots of developments within the last 12 months which are worth discussing. We will, of course, speak about the current state of negotiations between the European legislators. We will discuss how generative AI systems, such as ChatGPT, should be regulated. And we will also look at what is needed for a successful implementation of AI made in Europe. Now, before I introduce our panelists, I wanted to give the floor to Brando Benifei because he told me yesterday that he is only available for the first 10 minutes, but I see when I look at my panelists that he is not yet there. Good morning. Then I think we will start with the introduction of the panelists. Three of them are joining us from Brussels. Good morning, and let's start with you, Kilian, from the European Commission. We have Kilian Kroos with us. Kilian is the head of the AI Policy Development and Coordination Unit within the Directorate General for Communication Networks, Content and Technology, and his unit has been in charge of drafting the AI Act proposal. Kilian, thank you so much for being here with us today.
Good morning to Berlin, and thanks for having me there.
From the European Parliament, I'm also delighted to welcome again Axel Voss. Axel is a member of the Committee on Legal Affairs, where he is Shadow Rapporteur on the AI Act. Axel, good to see you again this year. Axel, you're muted.
No.
Yes, wonderful. Good morning.
Yeah, good morning. Do you hear me now? But
yes.
I have unmuted myself.
Yes, so we hear you perfectly.
Good morning to everyone, and thanks for having me. And I hope we will have a wonderful discussion this morning.
I'm sure we will. Thank you. Then we have Ursula Pachel connected. Ursula is the Deputy Director General of BEUC, the European consumer organization that represents 45 independent national consumer associations. And there she is leading the work on digital policies, and amongst others, she has been member of the European High-Level Group on AI. Very glad to have you with us, Ursula. Ursula, you're also muted. This happens. Everyone. No, not yet. We cannot hear you yet.
I am not muted.
Yes, now we can hear you. Wonderful.
Okay.
I guess it just takes some time to Berlin. The 800 kilometers is just too far.
Guten Morgen, Berlin. Ich freue mich, hier zu sein.
Yeah. And sitting right next to me here in the studio is Franziska Weindauer. Franziska is the CEO of the TÜV AI Lab, which is a joint venture of the TÜV organizations to develop standards for testing safety critical AI systems. And previously, she was head of public policy at Bitkom and senior policy advisor at the German Federal Chancellery. Franziska, good to have you here. Good morning.
Thank you.
You're not muted. We hear you perfectly. Do you have a microphone? Yes, okay.
Yes, thank you.
Wonderful. And now I see that also our fifth panelist is there, Brando Benifei. A very good morning. I already introduced the other speakers to you, but as you have only a few minutes time, I will just say something about you. Brando is a member of the Internal Market and Consumer Protection Committee in the European Parliament, and there he is the leading rapporteur on the AI Act. And as I said before, due to time constraints, Brando will not be able to participate in the discussion today, but you took the time to share your views on the current AI Act negotiations now. So thank you very much for being here today, and I hand over to you, Brando.
Yes, thank you very much. In fact, I was in the backstage, so I heard the presentations, but
So,
Sorry, yeah, I think there was a technical issue. Okay, so I was saying that I heard the presentations from the backstage, but in fact I know these people here. We have been working together to deliver this regulation. Um, I will be very brief, but just to give you an idea of where we are. Now we are in the final stages of these negotiations. We are preparing a possibly final trilogue with Council to deliver a final text of this regulation, which can really be, as I said yesterday during, I was connected from Brussels with the Reuters forum in New York, it can really be a blueprint for other interventions all over the world. Now that we have the executive order in US that also hints at further legislation, and we have discussions in other countries, sorry, of the world about how to deal with AI, maybe going over merely voluntary schemes. The AI Act is a blueprint for a sensible regulation, because it doesn't just say we apply certain rules to all AI, which I have to say, and I need to underline, AI is today already regulated by a lot of laws, because it's already in our life. So I give you an example. In my country, in Italy, there was a suspension of a generative AI system for some time for more than 1 month by the Data Protection Authority because of violation of GDPR. So the AI already needs to follow existing rules. The point is that with the AI Act, we concentrate on identifying some use cases and so context areas where AI can be more risky because they are sensitive areas. I give you a few examples, like administration of justice, the healthcare, the development of children, the critical digital infrastructure. We are still negotiating on this list of sensitive areas, but this is the spirit of the regulation. We do not regulate technology in itself, but we regulate risk based on use cases and in the context where AI is used. This way, we have a regulation that can be more future-proof, being more technologically neutral, as the AI technology is evolving a lot. If you think of the debate in 2022 compared to 2023, we see the big difference with the emergence of particularly powerful models and the generative AI. So we want to concentrate with this regulation on the higher risk use cases to give further protection for our citizens, consumers, workers, businesses, institutions, and also to a select number of use cases even say that we do not want them, that we want to prohibit them because we think they are too risky. And in fact, we live only with some general principles and some lighter obligations, all the other AI systems. For those that are high risk, we foresee a certification process for conformity that includes checks on data quality and appropriateness, data governance, cybersecurity, human oversight, environmental impacts, etc. This is something that we consider necessary for high-risk AI use cases. And with this risk-based framework, we have the objective of building trust on the intake of AI that will be more and more, but also to have a unified market. I need to remind that this is a market regulation, and so it has the objective to avoid fragmentation. But the things stay together. We build trust because we have the same rules, there is legal certainty. And finally, to give you the final, the final point on the picture, as I said, we are negotiating, and it's one of the crucial points, on high-risk categorization, on the prohibited use cases, On the governance, so which are the supervisory authorities that have to make this law real, not just a piece of paper, national ones and a European level one. And finally, we have the generative AI issue. This is linked also to very powerful models, which we are discussing whether to give them some specific rules to prevent systemic risks from very high power models that would, to some extent, be an exception to the general rule because they are considered inherently dangerous, if not checked in terms of some risk. It's this kind of debate that we hear about the extreme flexibility and possible even lose of control of some very powerful systems that probably in the future will be at the basis of most AI systems that we use today. These models might be in need of an extra check even before they become an actual system. And finally, generative AI, this is the topic that is more evident today because it's used by a lot of people already. On generative AI, we work on transparency provisions to make it recognizable when a content is AI produced, so to watermark AI generated content. This is the topic of the debate today with the Council. And also some protection for copyright. I know Axel, I'm sure he will say something about this because he is particularly attentive on this point, but I agree with him. It's very important. We want to give a clear message to creatives, authors, that their work is being protected. This is not a backward battle because we do not want to defend a conservative approach on the business that I think some business organization might have. They just don't want to change. But we want to preserve the creative workers from the extraction of value of copyrighted material without any possibility to put their case and have some leverage in front of the big AI developers. I think I gave you a very comprehensive overview. I hope it was clear, but I'm sure you will get more into specifics also with the other speakers. So thank you for the invitation, and I hope it will be a good debate and a good luck with the work of you, but also of all the colleagues and people that are here and working on the topic. Thank you very much.
Thank you very much, Brando. This was indeed a very comprehensive overview, and you touched on several topics that I think we will be discussing today as well. You have to leave us, right, immediately. So, Brando, thank you very much for being here, and all the best for you in the final phases of the negotiations.
Thank you. Thank you.
Thank you. I just have one technical question. Could I get a clock inserted so that I know the time? We have 1 hour, but I don't want to overshoot. So physical clock or digital clock would be perfect. Thank you. Now, let's start with the discussions. And I know, Kilian, you also have to leave us at 10. So my first question goes to you. Let's start a bit with the bigger picture. When the AI proposal was presented by the Commission in April 2021, it was considered as the first ever legal framework on AI. Now, 2.5 years later, there have been numerous other policy initiatives, and Brando mentioned some of them. Just last week, US President Biden issued an executive order on safe, secure, and trustworthy AI. We had the high-level AI Safety Summit in the UK, and we had also the G7 countries adopting international guiding principles on AI. Now, Kilian, is the EU still the frontrunner in regulating AI, or are we being overtaken by others?
Thanks a lot for the question, which is, of course, very relevant. I have personally no doubt that we have been the front runners in this important issue, and that we are still the front runners. Because you have to remember, when we started this journey in April 21, already based on quite some intensive prep work, because we had a 2-year high-level group elaborating 7 principles. We had already developed a tool. We had a white paper with a consultation process. So we had basically 3 years of groundwork. And we came with the first comprehensive legal act on AI, which Brando just has described, I think, very eloquently, which is really a horizontal legislation and covers the problem in a comprehensive way. When we started this, some others were saying that it's usual, the EU is regulating, the others are innovating, and we are too prudent, and the others are more grabbing the chances. Now this has completely changed. Now you see that in the US, they're thinking about, Senator Schumer is thinking about a bipartisan legislation. We see AI legislation drafts in California. We see them in Brazil. We see other parts of the world thinking about it, even in Africa and Kenya. We see international activities. You mentioned the UK summit, but there's as well, of course, the code of conduct from the G7, which has just been adopted on AI. So there's a lot of activities now, and even China, with perhaps a different angle, is starting to regulate this. So I think that there we have a bit, we have started earlier, but I think we were in the right, we worked in the right direction. Now have the others overtaken us? First, this is not a race. We are happy to have others on board. We always said this is international activity. We are very happy if like-minded partners join us. We always offered this. We want to have open standards for everybody. This is not to close up our market. This is to defend our values. So if somebody joins this journey, he or she is most welcome. And second, we should not forget, we in the EU, and that as well President Biden has clarified, we have a comprehensive legislation which is enforceable. The other acts, international acts, are to a good extent so far codes of conduct, but there's still a lot of work to be done. There is not always a very clear enforcement. The executive order in the US is a bit different because it's based on the Defense Production Act. But still, the enforcement is more limited than what we have, and it's a lot more as well exploratory, because if you read the executive order, I don't want to downplay its importance. I think it's a very, very important document and gives us a lot of inspiration, and we're happy that it's there. But I still think if we manage now, as Brando put it, to conclude still this year on the AI Act, we could say that Europe is in the lead, because we would be the first with a really hard law on AI, which addresses all the different aspects. So I think that would be a great success for us if we could show a bit the way in this important area.
Thank you, Kilian. It's not a race. It is an open endeavor. It's hard law. We are on a good track. Thank you very much. Axel, let's continue with you. You are also in charge of negotiating the AI Act, first within the European Parliament and now with the EU member states. Now, what is your view on the general process of the negotiations? Do you think, are we almost there yet? Do we have almost an agreement, or is there still a way to go? You hear something, in the media, but it seems you're still a bit struggling.
So, thank you. Yes, so I still have some hope that we might come to an end at the 6th of December, the last trialogue, probably for this year. If not, we should do everything to come to an end before Christmas time. I can't see how this is making more progress if we are postponing this to a next presidency and so on. So I think it might be good to have an end at the Spanish presidency. Of course, we have a lot of points open, let's say extreme points for Council and Parliament, and here we have to find a way forward. EPP is ready to go for finding compromises, but not at all costs. So what we are doing should be should have the intention of promoting innovation, should have the intention that everything is functioning, and we are not having speed or setting speed over quality at the end. But of course, in this compromise way, you have to give a little bit, probably also in this regard. What the most important thing for me is that we are not first in regulation, that we might be first in developing AI and find a kind of a proper frame for using AI. And this is the most important thing. So, of course, I'm not quite sure if everything what we are doing will be in line with everything what is now discussed on this international level. But in a way, we are probably giving them a lot of ideas how to deal with it. At the end, the European Union is always putting or linking values to the technology, and this is, of course, what I think at first we can provide to the world here something, and secondly, this is our way forward. Coming to copyright, data protection, these with the sandboxes, these mixed foundational models, biometric data governance, still are very important points open. Sometimes, it's dependent on the day-by-day feelings that we might come to an end or not. But still, there is this hope, and probably Kilian would better know how the process on the technical level is going on, and that we can achieve here something. But of course, for me, it's quite important that we have some minimum aspects of copyright in it, that copyright holders might also enforce their rights still under using algorithms or large language models and so on. But this is only the idea of enforcing rights of others. We are doing this everywhere for consumers, but why not here in the for the copyright holders? Also, this has some aspects also for personality rights. If you can keep a kind of a full documentation, and this shouldn't be a question for everyone, because we have to find a way that we can still enforce rights here. On these biometrical data, of course, the EPP has not the majority in the parliament, but our line is also that, of course, our law enforcement in administrations should use also AI algorithms and for their works, but then we can frame it a bit that the fear of overusing of or to use these for the wrong purposes, etc. This is, I think, what we can frame. On the governance structure, I would always say we should not have the same, or we should not do the same mistake what we have done with the GDPR, where every member state can interpret the European rules on its own. Here we should have this common approach and one interpretation on the European level, and this would be the minimum what the EPP is asking for. Otherwise, we are fragmenting ourselves, and this wouldn't be a good starting point for the European AI industry.
Thank you very much, Axel. You already named some issues: government structure, copyright, biometric data. I think these are really the crucial points as well. 6th of December, this is quite ambitious, so it's in a month. Very good luck on this, but I'm sure you can do that. Over to you, Ursula. You are representing the European consumers, and you have also been following the negotiations quite intensively. What is your verdict about the current negotiations, and would you say that the main risks for consumers have been adequately addressed?
Yeah, thank you very much for this opportunity. Indeed, we've been following the AI Act and the preparatory work since quite a long time now. And let me maybe just say we've come from an AI Act proposal, and Kilian knows our position on that, which certainly did not take into account sufficiently the consumer perspective. And this despite the fact that the European Commission had already in 2020 declared that the AI Act would be a major tool for the European Commission's mandate to protect consumers in the digital environment. So we've come, I think, with the European Parliament work in particular to a situation where the proposal has improved from a consumer perspective. There are also some positive points from the Council, but let me just say that AI is very, very important, of course, for consumers, and that consumers are confronted and will be even more confronted with these systems in their daily life. And there is a high risk, of course, that consumers will not benefit from free choices that they can make, that there will be manipulation, that there are intrusive practices regarding their privacy, their personal data protection, etc., etc. Safety, security, all these type of topics are fundamentally important. And it's not, I think Brando said that, it's not about really regulating technology, and it's not for consumers to trust technology. It's really about consumers to trust the governance system that ensures that the AI technology is used appropriately and that they are well protected. And also, if something goes wrong, that they are having means to redress. So all of this is at stake. And if you ask about the current situation, I would say that there are still points open that are going to be decisive in what consumers will have as a regulatory framework for their protection. So I'm talking about the practices that will be banned. I'm talking about the regulations for generative AI. We are also, I mean, we understand that the question about an impact assessment about fundamental rights that AI systems would, or the providers of these would have to undertake, this is still under discussion. So what I want to say with that, fundamental issues are still open, and the next weeks will be absolutely decisive in the way Europeans will be protected or not. Maybe just a few examples. In relation to what practices are unacceptable and thus should be banned. For us, one of the major points is about remote biometric identification, facial recognition in publicly accessible places. This is a very important point of discussion, we understand, for the member states, mainly also when it comes to national security. From a consumer perspective, we are looking at commercial uses of facial recognition in publicly accessible spaces, meaning if you enter into a supermarket, into a shopping mall, is it possible for a trader to scan you, to identify you with your biometric traits? And we think this should be banned. It is a much too intrusive technology. It is a much too intrusive, would be a much too intrusive practice in terms of the privacy of people. And this was not foreseen in the Commission proposal, but we really hope that it will be banned finally. Another example is emotional recognition. AI systems can, to a certain degree at least, and will probably become better on that, identify the emotions that a person has, and of course that could be commercially exploited. Unfortunately, this has not been banned, and I think there is not a lot of hope that this will still be banned in the current negotiations, which is really a pity. We will allow traders basically to do these type of things, and I don't need to, I think, explain the high degree of manipulation that is possible with these type of systems. At the very least, we hope that these emotional recognition systems would be qualified as high risk, so that they at least have to fulfill the requirements that are foreseen, including third-party assessments. And then maybe for the generative AI, let me just say that we have been really alerted by the last leaked documents, which in our opinion included wording that was very vague, very complex, very difficult, which would have only regulated certain generative AI systems on foundation models, very capable models, who knows what that is. On generative AI, only systems that are big at scale, which is not good for consumers, because consumers don't care if it's a small company, if it's a big company, what it matters is the protection they have. So I stop here, but what I wanted to convey is the message: there is still so much at stake, so we can only encourage the legislators to get it right for people, which is the overall objective, the well-being of Europeans. Thank you.
Thank you, Ursula. Very important points. Generative AI systems, remote biometric identification, emotional recognition systems, also, I think, very high on the agenda of the European legislators. And you said the nice sentence, consumers don't trust the technology, they have to trust the governance system. And this is a perfect way to you, Franziska. You are representing the TÜV AI lab that looks into how AI systems can be assessed and certified. What is your view on the AI Act, and how do you evaluate this risk-based approach, this governance system, and also the role of certification?
Yes, thank you very much for having me. I'm looking forward to the rest of the discussion as well. And I was already very pleased with your inputs, Ursula, what you said about that people have to trust the governance system and not only the technology. I think we've seen over the past decades and centuries that it's really important to do everything so that people can trust the technology and indeed the governance setup. And I think the AI Act is getting a lot of things right. I think the risk-based approach is really the correct approach and the only approach which could have convincingly have been chosen. So I think that's done well. Essentially, also the requirements that have been set out with robustness, accuracy, transparency, etc. I think that's also convincing, and also a lot of that stems from other regulation. I think the devil, as always, is in the details. So I think the general setup is good, is done well, but of course we need to see whether the details are now being, and it's always also dependent on the last meters of negotiations and the last minute compromises in the morning at 3 a.m. And who's still awake enough to stick to which point. So I think it's really it's up to the legislators and up to the details. I think one concern is whether everyone, for example, with Annex 3, the self-assessment approach, I think that's in principle okay, but we need to see whether it works in practice and whether all the things that are listed in Annex 3 should actually be in Annex 3, or whether we at some point, see that it's that the self-assessment approach isn't working. And I think it's not so much about the European players in that sense, but also about the international players, and we've seen that in other domains. The second point I would like to make is that it's all about implementation. It's like communication is key, implementation is key. And I was very glad to see that, Axel, you mentioned the negative example of the GDPR. It's also my favorite negative example of how not to implement an act legislation in Germany, especially. And I think we as Germans are always overly diligent and overly precise, and sometimes overshoot implementation a bit. And we really got the governance, I say we in Germany got the governance set up wrong. There were too many institutions, too many agencies, too many cooks, as we say in Germany, that cooked the meal. So I hope we get that right with the AI Act, that we get the implementation more lean and more simple and better. And the third point I would like to make is that I think it's key to coordinate internationally. As we know, problems and risks spill across borders. Deployers of AI operate internationally, and I think we've seen a lot of activity, but from my point of view, it's at a very early stage. It's good that we talk, and we have a lot of channels and a lot of processes with the Hiroshima process, G7 Hiroshima process, etc. That's done. It's good that we have that, but we still need to see some real results from that. And I think also we need to see that the AI Act is not the only law, and maybe not even the most important. If you look at a lot of sectors, like the medical sector, we have the medical device regulation, etc., which really is key for making sure that AI quality is done right. So we need to also see that the APIs between the laws are, that every law actually states the same, and that the AI Act says the same than the MDR. I think that's a point we need to focus on as well.
Thank you, Franziska. Also very important points. Now, Kilian, I know you have to leave. Can I ask you one last question? Yes, I take this as a yes. Let's focus on the topic of generative AI, because this was a topic that I think all of the speakers mentioned. Now, a year ago, we had the same discussion here at our TÜV AI conference, and ChatGPT had not even been launched. So the issue of general purpose AI, foundation models, generative AI systems was not really there. It has only been in the last 11 months that people really became aware of the enormous potential, but also the inherent risks of such systems. And for the European legislator, the question is now, how do we regulate these kind of AI systems? And I would be very interested in hearing your opinion, Kian, because I know that in the Commission proposal, this was not very much addressed. So what do you think? How should very powerful AI models such as ChatGPT be regulated?
Well, thanks for the question, because you did find nuance. It was not so much addressed, because it's correct. We have already some rules in the Commission proposal on generative AI. In particular, Article 52. We have a provision that you have to inform the affected person if they are interacting with an AI, and we have a very important provision about informing everybody when they're dealing with deepfakes. And of course, every general purpose AI system, if it is used for a high-risk purpose, so if, for instance, you use ChatGPT to, for instance, to select recruitees, so you ask ChatGPT, you give 3 CVs and ask ChatGPT who would be the best for my company, it would become a high-risk purpose, and then, of course, you would need to undergo the high-risk conformity assessment. So I just want to say this, because often we hear the AI Act that shows already that it's not possible to regulate because things are moving so fast, so you didn't cover it. I think it was covered. Nevertheless, it makes a lot of sense now, as we have the opportunity, and of course this has developed very much and has received a completely different importance now and dynamic, that we take the time and to think about whether we need some adaptation and fine-tuning of the rules. I don't think we need to develop completely new rules, but how can we adapt a bit in order to cover these very important systems in a comprehensive way. And they're the first, and now here, of course, the discussions are going on. But I think there are certain strands or certain key elements where I think we mostly agree and which make a lot of sense. One is we have to ensure that if foundation models and afterwards general purpose AI systems, because we distinguish, we basically say GPT is a foundation model because it's not really usable directly, but ChatGPT with a chatbot on top is a system, is directly applicable. That these systems, if they are high risk, can be assessed, conformity assessed in a meaningful way. And that, of course, requires that the provider of the high-risk system has the information how the system has been trained. This is a very simple principle. The Americans call it garbage in, garbage out. So if the model has been wrongly trained or badly trained, it's very difficult to correct this downstream. And as we expect that we will see a lot of fine-tuned high-risk systems in the future, so a multitude of applications and systems built on these large models, because they will be basically the starting point for a lot of developments, it is important that we get the starting point at least documented, that with a minimum of transparency, in order to allow then the provider of a high-risk system which is built on that. So what I'm speaking about is setting up, for instance, a high-risk system on giving legal advice for legal professions with a high-risk area, based on a foundation model, and then fine-tuned, for instance, with particular input on legal material, judgments, legislation, and so on. But then the provider of this high-risk downstream system needs to have access to some information in order to make sure that he or she understands the data set and has a bit of an overview. So that is, I think, one key requirement where we can all agree that this is very, very important. Another element is, of course, to think about that in the future we will see a lot of generative AI. So because these systems are mainly used to produce content, it be audio, video, or text, and there is an increasing need. We had a provision, as I said, on deep fakes, but there is now a very important discussion whether we do not need a bit more, whether we do not need some provisions reflecting a bit about that you can trace whether content has been synthetically generated, so that you in the future are able to distinguish human-created content and synthetic-created content. We have some sympathy for this because we think that could, for instance, make the work much easier in the framework of the DSA for flaggers to see whether something, for instance, in campaigns has been artificially generated or has been naturally generated. And we all know the example of the university professor who is not able anymore to distinguish whether a paper has been written by a student or by the machine. So I think there is a need, and I think I would see there some opening to develop this further. Then Axel mentioned already there's a copyright issue, which is a big issue for the right holders, because these systems are trained on a lot of material. We need to reflect a little bit. I think we don't want to change the copyright rules, but we need to reflect a little bit whether the enforcement of the copyright rules is sufficiently appropriate for these systems, or whether we need a bit of fine-tuning in order to allow this. The Parliament made a proposal in this respect. We will discuss this, but this is certainly a justified concern to make sure that the enforcement of the copyright rules works well. And then there is the question, what was discussed in London, whether there are particularly powerful systems which may generate really a new type of risk, which is sometimes called this extinction risk or systemic risk, or because there's a particularity of these systems that they have sometimes capabilities which we do not even know when the systems are developed. So as an example, when GPT-4 was developed, the developers didn't really realize how well it could code. They developed it for text, but then they realized it's very good in coding. So these systems may develop capabilities which are not really predictable. And that, of course, may create a certain risk, and therefore we are reflecting whether we need a bit more supervision on these systems in order to understand these risks a bit better. So I think that's a bit where we are working. I see there that the co-legislators have a lot of common. I think the idea, the concerns are rather similar. It's a bit about the way how to get this right, because another aspect which is as well very important, and we should not forget, and this is the underlying balance of the whole exercise, we need innovation and regulation. So we don't want to over-regulate neither, because we see so far most of these very powerful systems are unfortunately not European. We have some very good European companies now. We have Aleph Alpha in Germany, we have Bloom, we have Mistral in France, we have Sweden AI. So there are new elements coming up, but we need, of course, a framework as well where these initiatives or others which may come in the future may flourish, because we want as well that our European cultural heritage is represented in these systems. I think that's as well an important aspect, because if we only use systems which come from overseas or from other parts in the world, they will not be the European languages and not be in the European, and we will of course be cut off a very important economic work strand. So this needs to be brought into balance, and this is perhaps what I can say at this stage, what we are reflecting and discussing together, which are I think very important and very relevant questions.
Thank you, Kilian. A much more comprehensive overview than I thought. And I hear a bit that you're also proposing this tiered approach, which I think is also being discussed currently in the trilogue negotiations between the Parliament, Council, and Parliament. So, Axel, over to you. Do you agree with what Kilian has said? Do you agree with this tiered approach? So, transparency obligations for all models, and then perhaps more stringent requirements for very capable foundation models?
So I would say a couple of weeks or months ago, I was always thinking that foundational model and GPAI is more or less the same. If we are now differentiating here, I do not know if this is really helpful at the end. So I would always say we should concentrate on foundational models and the burden sharing to then the added, probably high-risk usage of foundational models. But I'm not sure if this category of then general-purpose AI is making a lot of sense here. So this is where I would say we should more be concentrating on the, let's say, real problems instead of creating new ones. Where I do not agree really, but Ursula probably expect these already if I'm here in the panel or at the panel. Consumer protection is for me differently than fundamental rights protection. So this has different aspects. As a consumer, you have to have a kind of a contract, and what is mentioning here with banning everything. So it doesn't have a kind of a contract as a fundament. And so, but if we're concentrating on fundamental rights aspects, then of course we have some systems where this might be necessary to focus on, but not all of these AI models are always having a kind of a fundamental rights aspects in it. So that's why I think we should concentrate on what is really needed. And we have to have in mind that we will not win the digital race without data, and we will not win if we are not innovation friendly. And here AI is the fundamental aspect of everything what is coming in the future. And therefore, we also have to have a kind of freedom of innovation somewhere. But it's also, and this is not really addressed to Ursula, but to my more left-wing orientated friends in the House. Just banning is always easy to say. Why not going the extra mile in balancing everything? Because in the AI or in the digital world, you have a very thin line where you can have good things and bad things. So, and here we have to more focus on, instead of saying, oh, we have to ban everything. So this is something what I wouldn't agree if it's because it's too easy for me and just saying, oh, we have to get rid of some of these aspects. So still, I think if we are coming to these generative and foundational models, AI systems, we need to make sure that this is working and that we have a kind of a burden sharing. And then this is, if this is risky in a way, then we have all these requirements in place. And I do not think that. So what we can do really good is always in protecting consumers and individuals. But what we can't do really, I have the feeling that we are then striking the right balance for it. So here I think we need to be better. And so that this is what I would like to say to these points. We shouldn't do it, or we shouldn't make it ourselves too easy, because it's so important that we are still a part of competition throughout the whole world. And if we are only concentrating on minimizing everything because there is a risk, probably we wouldn't have a car in place where we can drive with, because it might also be risky for the lives of others. But we need also to take risks on board, but we can minimize what we are always already seeing, but not minimizing this to an end that we are not using AI at all.
Yeah. Thank you, Axel. And you brought the discussion to the question I also wanted to ask all of you, this delicate balance between ensuring protection and enabling innovation. I think this is one of really the fundamental discussions that we're having on the European side right now. And Ursula, I mean, you were addressed directly, so let's ask you, is it really true that a high level of protection can only be achieved at the expense of competitiveness? Or is it possible to balance really these two objectives? What is your view? Or should perhaps one objective be prioritized over the other objective?
Yeah, thank you very much for that question. I would also like to respond to Axel. I have to, but maybe I can do that afterwards if you allow me. But I really have to respond to you, Axel, about the fundamental rights issue. I think that is very important. But briefly on your question about innovation versus protection, or whatever you want to put it. I think the discussion we currently have on competitiveness and innovation is just a bit wrongly shaped, because what we would like to see instead is more acknowledgement that regulation should be seen as enabler of innovation, namely innovation that we want, innovation that serves people, that serves the welfare of consumers, of citizens, of our societies. This is the innovation that we want to enable with the regulatory framework that we are building. And this type of narrative, unfortunately, is not very dominant at all in the discussions, and I think there should be much more, because the decision to do so has already been taken by the European Union. I just want to recall the last year solemn declaration of rights and principles for a fair, safe and secure digital transition, where the European Union, all institutions declared that they want to have safe and secure AI, that AI should serve people, and that it should serve the ultimate objective of human well-being. And this is all endorsed by the European Union. So I don't think there is a real question about what should take precedence, right? Innovation has to serve people. And this is why I think competitiveness in that sense can really also be a real advantage for the European Union. I think we all have heard about Anu Bradford's famous book about the Brussels effect, and saying that this is something that the European Union really has well done to put regulation at the forefront as shaping our societies and markets, and that has been a win. And we heard it in the beginning when Brando said he believes the AI Act will again be inspiring for many other jurisdictions. We can only hope so, because that is what we need. We have seen it with the platform discussions, but we started to regulate far too late, and we just hope that now with the new regulations that there will be a difference for consumers. May I say one sentence on the fundamental rights? Is that okay?
Yes, briefly.
Yes, very briefly. Axel, because I think you said consumer protection is different from fundamental rights, which obviously is not the case. There is a principle of a high level of consumer protection in the Charter of Fundamental Rights. The problem we see now is that fundamental rights is increasingly used in European legislation. It's used in the DSA, Digital Services Act. It's used in the AI Act. Nobody really knows what that means. So if you have to make an impact assessment on fundamental rights impacts, I think we first also have to clarify we are in favor of that, but we will need additional tools to tell businesses what does it mean. And there is a lot of consumer rights in fundamental rights, like the right to privacy, to personal data protection, to dignity, to safety, to integrity of health, to non-discrimination. So there is so much in it, but I think we have not yet understood, and it's, I think, problematic to always refer to fundamental rights in legislation, because it seems to be a substitute for what would need to be something much more concrete, namely, for example, more concrete and updated consumer rights. So I just wanted to make that point clear, that of course consumer protection is part of the Fundamental Rights Charter. Thank you.
Thank you very much, Ursula. And over to you, Franziska. When we speak about protection and competitiveness, we also speak about compliance. And users of AI systems must have trust in the safety and security of these systems. Can you tell us a bit, Franziska, what you are doing at the TÜV AI Lab, or what your goal is, and perhaps also indicate how far the TÜV organizations are when it comes to assessing AI systems?
Mm-hmm. Thank you. I think this also goes to your earlier question about innovation versus protection of consumers. I think in order to not make it a prisoner's dilemma, and in order to get both things working, I think it's really we're working in the AI Lab. We're doing everything we can to prepare the European ecosystem for the AI Act, and I think that's crucial. And again, I would like to refer to the GDPR. If we do it better this time around, and if we prepare players, especially the economy, for the AI Act and other legislation on AI that is to come, I think we can avoid this dilemma, and we can do both things. So what we're doing in the AI Lab is essentially three things. We want to help develop standards that reflect the legislation in time. We want to come up and develop quantifiable conformity criteria and test requirements for AI system, and also help develop test methods for AI systems. So in short, do everything so that we're able, when the AI Act enters into force, that we are able to audit AI systems either voluntarily or mandatorily. And I think it's really difficult to say where we are, because it really depends on what you look at. In the medical sector, for example, we can already audit AI medical devices which are static. So where the AI is not, after being audited, it doesn't develop further. So it's static AI systems. But what is really difficult is, of course, to audit dynamic AI systems, because then, of course, they develop further and they, develop new use cases and new skills after being deployed. So that's something where we also need to rethink the whole certification process. And I think that's something that is where we are really early stages, but where there's a great ecosystem of players that is doing a lot of work.
Thank you. It takes, but you're on track. Axel, I think you are in contact with lots of businesses. What is your impression? Will AI developers and providers be ready to comply with the requirements once the requirements take legal effect? So I don't know, 2025, 2026. And also, perhaps, could you tell us a bit about this concept of regulatory sandboxes? I know it's very popular among the European legislators. How do you imagine these sandboxes to work in practice?
So, coming to your second question first, regarding sandboxes. For me, it's quite important that we, because of this confrontation or conflict with the GDPR, because for training your algorithms, you will need a lot of or massively personal data. So if the results should be non-biased, non-discriminatory, gender balanced, and so on, then you have to train your algorithms with a lot of personal data. And here, the Data Protection Administration, in their interpretations, then are saying, no, you can't use these for different purposes, ignoring totally probably Article 6, paragraph 4 in the data GDPR, and where you can, of course, also change the purpose of processing your data, but you have to justify. So, but here we need to have a kind of a more simplifying approach because of this extreme importance of this innovation of algorithms. So that's why we need to have also in these sandboxes more than less, let's say, two elements. So avoiding this conflict with the GDPR, meaning that companies should come to the sandbox and using their own data and saying, oh, now we would like to train on this data our algorithm. And of course, there might be also some companies which might be new and do not have data, and then also sandboxes should provide these data for training and the idea of an algorithms of the young company. And then the idea should also be, if you're once leaving the sandbox, you are ready to go to the market. And you do not or should not do any or more than this and having this in place. And also here might help a kind of a standard, what should be created as soon as possible, where companies can rely on, if they are using this standard, then they are in line with the requirements of the AI Act. This would be an ideal situation, and here we have to make sure that the bureaucracy is not overburdening everyone who would like to use these. But this should be a tool for companies or for everyone who would like to test and to train its algorithm. And this should be kind of a help. But if we are now then again having too much requirements for all of this, nobody will be interested in using this. So this should be a kind of the idea of helping. If companies can comply with the AI Act and with all these requirements and obligations, of course, it's how it always is, the big ones will, and they do not have a problem with these, but the little ones or the micro and medium-sized companies, they will have a big problem in complying with these because it will cost a lot of money what they might not have. And here also we should think about, in combining these two elements, that we should have some instruments in the sandboxes that for small companies, that they have a kind of an added value immediately. Also, with the bureaucracy, what we are implementing with this AI Act, what I still think is too much in it, because this is not a kind of an easy starting point for everyone. But if we are accompanying these with different elements, especially also with programs and supporting small and medium-sized companies, then this might help at the end. But having this alone implemented, then I see a kind of a not easy way forward, especially for the small companies.
Especially for helping the SMEs to comply with the requirements. Franziska, that sounds like the TÜVs can also play a role there, right?
Yes, absolutely. I think it's especially for the smaller players. We've seen that with a lot of other regulation, European regulation, like the DSA and DMA. It's easy for the armada of lawyers that Facebook and Amazon have, but it's always tough on the SMEs and startups. So I think we need to make to put the spotlight on them and make it easy for them as much as we can.
Wonderful. Ursula, from the consumer perspective, what do you think is needed for a successful implementation? What's the key factor?
Well, that's a difficult question, but let me just say implementation will be absolutely crucial. And that has different levels, right? I have to say, we're not so happy that so much discretion is given to the standardization bodies now. They are already working, as we know, on developing the standards for the AI Act, though the AI Act has not been adopted, but they have a kind of a provisional mandate, if I may say like this. From our perspective, we should be very cautious on 2 points on standardization. First of all, there should not be too much leeway for interpretation to the standardization bodies. For example, in the AI Act, we think there is too much kind of given to the standardization bodies, who are in the end private bodies, to determine what type of bias prevention should be included in the processes of the AI system. So the question of how people will be protected against discrimination will, to a certain extent, depend on how the Senelec body will interpret what they have in the AI Act. So there is too much discretion, and I think these fundamental rights issues, like the one I just mentioned, are not specific enough in the AI Act and would need to be further concretized. And then there is, of course, not enough civil society inclusiveness in the standardization processes. I mean, this is a big topic, and I think we will have to discuss that much more in the future. All related to certification, as I think Franziska just mentioned, will be extremely important. And again, we think there is not enough discussion about the tasks of these bodies, like TÜV also does important work. But these issues like the dynamics of AI systems and how do you guarantee that certification can keep the path and that consumers will, for example, be protected and legal presumptions are correctly applied. So all of these, I think we need more discussion about this layer of implementation, which has many shapes and many formats. And because Axel is here, I also want to mention liability. We have a proposal for liability, civil liability of AI acts, and unfortunately I understand it is a bit stuck, but for people it's important to know, in order to trust, that if there goes something wrongly, that they can get compensation and that there is redress. So this is important. And the liability of these intermediaries who give certificates, who accredit, who conform conformity assessments, I think that is also a big point for discussion for successful implementation. Thank you.
Thank you, Ursula. Standardization, certification, liability, participation of civil societies. We've discussed a lot of issues. With these thoughts, I say thank you very much to all of you for this wonderful, insightful, and also engaging conversation. I have the feeling that while there are some questions remain, I think we are on a good way to make the AI Act a success. Axel, I wish you all the best for the ongoing trilogue negotiations. Did he leave? Because I only see you, Ursula.
No,
He's
I'm
still
still
there.
here.
He's there. Okay,
I'm
then
still here.
I'm sorry, Axel from the off. All the best for you, Ursula. For you, keep up the good advocacy work in Brussels, and Franziska, all the best for rolling out the AI assessment schemes. Thank you very much. Thank you for listening, and goodbye.
Thank you very much. Have a good conference. Bye-bye.